Everyone, I am Dominic Cull. I am ISPs Regulatory Advisor. And I am from Gritty Reality. Topic of my talk, what looming legislation should ISPs be concerned about? Hands up anyone who is concerned about something in the legal sphere in your job. We have a hand. What is it?
Complying to governmental regulations like this.
Okay. From Europe, we tend to follow Europe quite closely, so we have a similar issue in terms of compliance, so that's a valid one. Anyone else losing sleep about legal things? Good, because that is precisely where you should be at the moment. There is stuff coming. So one thing I'm going to highlight to you, which I think requires some thought and some preparation, but the rest is really just interesting and probably ultimately quite helpful. First things first, I have self-reviewed this presentation in accordance with the guidelines of the Film and Publications Board. It is not all ages, it is parental guidance because it is full of legalese. So be guided accordingly. And the one thing I do want to raise for folks is blocking and filtering. So we all know the situation where a copyright association, recently we had La Liga approaching ISPA to say there are unlawful streams of Spanish Premier League soccer matches which are available in South Africa. We want you to block them at source. And as we have consistently done for the last 2 decades, we said no. Go away, go and lobby government, go and get legislation in place which will achieve your ends and make us do what you want us to do. And ultimately, after about 25 years, we are now moving towards some kind of blocking and filtering regulatory framework for ISPs in South Africa. The vehicle for that is this audio and audiovisual content services policy, which is busy being developed. Government says that by the end of March next year, they will have finalized this and developed a draft audio and audiovisual content services bill to go for public consultation and to go into Parliament. Now, the vast majority of that process, that audiovisual content services paper, is about updating what we think of broadcasting. So the last time that we looked at this stuff, it was SABC 1, 2, 3, maybe ETV. The world has moved on. Very few people in this room that watch terrestrial, linear, traditional TV. We now watch Netflix, video on demand, etc. So the main purpose of this process is to update our framework to say, broadcasting is only a small bit of it now, but we also want to license the IPTV, the video on demand, and even things like YouTube are going to be pulled into a South African licensing framework. All of which is interesting, but there is now also an additional chapter specifically on filtering and blocking by ISPs. And recently, all of the copyright associations have been coming out of the woodwork to knock on ISPA's door to say, we're very excited because we think this is now going to happen. Now is the time for us to strike. And you will see over the next year or so, event after event being run by copyright associations to try and lobby government to make this as tight as possible. The tighter it is, the more painful it is going to be for ISPs. So we've been there. We've made submissions on this, the draft policy. But we're also trying to be realistic. 10, 15 years ago, blocking and filtering was quite rare around the world. As I stand here today, probably half the countries in the world have some kind of a blocking and filtering system. So this is not something we are going to be able to push out forever. And if I had to guess, I would say probably in about 10 years' time, we are going to have a set of regulations binding on ISPs and a process, for example, a gambling board to get an order saying, hey, Mr. ISP, are South Africans visiting www.internationalcasino.com. That is against the law. we now require you to block them, and you will have to go internally into your network and take the necessary steps in order to do that. To refer back to the top line, easy topic to talk about, but really, really hard to do, both from a technical and a legal point of view. So there's a lot of shaping of how this is going to look, which will take place in the next 5 to 10 years. And this is a wake-up call to people who hate their networks being interfered with, who hate being told what to do with their networks, who think that blocking and filtering is a great way to break networks, to be aware of what is coming down the line here, because this is something which is being pushed by government and being pushed by international organizations. So there's ISPA's position. If we had to choose a model, we'd look at Australia. Quite like the fact that in Australia they say, look, all our citizens have the right to access any content they want. So if you come along and you want to block them from accessing particular content, you have to file something called a disruption request. In other words, you are disrupting the right of that Australian to go and gamble on internationalcasino.com. And you will have to go through quite a rigorous process before an order pops out to an ISP to block that site. So if there's anything you walk away with from this engagement or this 20 minutes, please just be aware that this is coming. Start thinking about the different ways in which it can happen. Start thinking about ways in which, if you had to do it, it would make sense for you to do it. Oopsie. Oops. Okay. Cybersecurity, if you were here a little earlier, there was a chat from Warwick about some really interesting stuff happening in the CSIRT space, and that's where all the action is. So in South Africa, we don't have much. We have minimum information security standards. Can anyone tell me when those were drafted? Any guesses? Tough crowd. 1996. Okay, so you can only imagine how useful those are in 2025. We have a national cybersecurity policy framework, also of very little use, but it did give us the Cybersecurity Hub, which is something that we work with from the Department of Communications and Digital Technologies. And a lot of that engagement with the Cybersecurity Hub has enabled what ISPA is doing as presented by Warwick. So really the action is industry-driven, CSIRTs are operational, very constructive. If you read the media, you see increasingly announcements of security breaches, Pam Golding recently, a lot of others. That's because we now have a reporting obligation under the Protection of Personal Information Act, and they've even got an online reporting tool which you have to use on the information regulator's website. And what that's doing is starting to help us to realize just how many security compromises are taking place at South Africa's big companies. So this issue is being dragged out into the light, and that will have a positive effect over time. Later this year, there will be a cybersecurity bill introduced into Parliament. ISPA had a look at this about a year ago. We made 2 sets of inputs, and then it disappeared. It's currently going to Cabinet for approval, but probably, let's say, in the next year and a half, we will have specific, bespoke cybersecurity legislation, setting up new structures, setting and validating the existing structures, and probably placing some kind of obligation on the people in this room. So again, nothing to do now. Industry is actually leading this dance, but be aware that government is going to push in through legislation in the next year or so. Cybercrimes, interception and monitoring. We've had a Cybercrimes Act in force since the 1st of December 2021. Great piece of legislation. Again, from an ISPA perspective, we played a very constructive material role in shaping the provisions of that legislation and how they apply to licensees and the industry. Just be aware that that has not been implemented completely yet. So we're waiting for the Minister of Police to issue a notice saying these are the cyber crimes which ISPs must report. And then we are also waiting for all the forms to be used. So those of you who do these things, you will know that where you hold information about a subscriber and the state wants, or SAPS wants to get hold of that information, they will generally issue you with a subpoena under Section 205 of the Criminal Procedure Act of 1977. Once these forms are finalized, which could be any day, we will move away from the Section 205 subpoenas, and you will start engaging with SAPS through things called preservation directions. So SAPS order you to keep a set of evidence about a particular subscriber in a safe, secure location until they come back and ask for it to be released. There'll be disclosure directions and all kinds of things, which once those forms are in place, we will be rolling out training for the community so that you know what to expect and how to deal with it. RICA, that's interception and of communications, been a pain for the industry ever since it came around. Customer registration is the particular pain point you know. But most of the people in this room should also be aware that because of lobbying, you are being saved from a lot of pain under RICA. For example, you don't have to retain metadata for a period of 5 years, as some other licensees in South Africa have to do. But it's broken, and we know that customer registration doesn't work, and there are lots of ways to circumvent it. And customer registration has been hugely problematic as a competitive issue in the industry. Why? Because some people are, this is the law, I must follow it, and others are, we don't really care about that, we'll just sign you up, don't bother about giving us an ID or a proof of address. So some of the established ISPs complain that they lose clients and they have churn because of RICA. So the good news is that that's all going to be rewritten and modernized. The Department of Justice is responsible for this. With ISPs input, they have written a policy paper, and they're looking at things like, we'll make the entire know your customer registration process online. We'll interface with the various Department of Home Affairs databases, et cetera, et cetera. So the way in which it's moving, RICA is not going to be a pain in the ass anymore. It's going to be a simple functional part of sign-up achieved really quickly. So probably in the next 2 to 3 years, we will see that, and RICA will become less of an issue in your lives. In that review, we're going to be very careful about any attempt to impose data retention requirements on ISPs. We have shown SAPS that it's not necessary. We have shown SARS and others that it is not necessary to do that for law enforcement purposes, and we'll really push that. And then just note that both ICASA, the Independent Communications Authority of South Africa, and ZADNA, the .za Domain Name Authority, are both pushing to get involved in customer registration at the moment for reasons which escape me, and certainly not compelling logical ones. ICASA is saying now when they issue you numbers, they're going to include some kind of RICA obligation when you hand those numbers out. And ZADNA, we'll touch on a little bit later, but they've got a set of regulations which says that if you are a registrar, you would need to undertake a know your customer registration process before you provide a domain to a registrant. So a lot of action around there. Hopefully we'll persuade ICASA and ZADNA to go back into their boxes, and we'll leave it to the Department of Justice to hopefully give us something a little more sane. Competition, just very quickly, Mazev, ongoing drama, you've seen it all. That now goes to probably the final step in the Competition Appeal Court from the 22nd to the 24th of July, I think it is. So probably the only thing I want to highlight out of there is the tribunal saying to Vodacom, what we see you trying to get out of this deal relates to something called VAR, not video assisted referee, but value at risk. And what they're talking about there is for Vodacom or any MNO, Where they have an area where people have money, a Santon, they get a lot of spend on the mobile product, but as soon as a fiber line comes in with a Wi-Fi addition, Vodacom sees its revenue plummet. So Vodacom sees CivH and others rolling out all this fiber, and the net impact on them is a reduction in revenue and a reduction in profitability, and that, says the tribunal, is the real reason you're pursuing that deal. And that's actually a really nice way of conceptualizing it, particularly for people in this room who are the active agents in putting that value at risk. The Commission is also looking at complaints about monopolies, both at the network level and the ISP level in gated communities and estates. So lots of complaints are coming into the Commission to say, hey, I live in this complex and I don't have a choice of ISP, or even there's only one fiber network operator, which is problematic. Can the Commission please do something, because we believe that's anti-competitive? That will play out this year. Also playing out this year, you're seeing all the new FNO models going into the lower LSM areas, into the townships, the fiber times, the wires, et cetera, in the news recently, Zoom fiber in particular. And where you take a low-cost model into those areas, it puts the open access model under severe strain. You're looking at very narrow margins, and you're thinking to yourself, isn't it easier for me to just do this through my own ISP rather than allow third parties to compete, because my margins are too low to actually have the infrastructure for open access? So that is something which we're going to be fighting about quite a lot this year. And then the last, looking at the time, last issue there is mobile virtual network operators have doubled their revenue in South Africa over the last 2 years. ANTS figure that in Germany, 50% of mobile services currently provided by mobile virtual network operators. So that aspect of the market is going to continue to grow, and it's really a very intuitively simple thing, because it's exactly what happened with the fixed ISPs under Telkom. Okay? Telkom, sole monopoly. As soon as there was competition enabled by IPC, enabled by uncapped and other things, you started to see the price of fixed services going down because of that competition. Exactly that process is now happening under the MNOs with mobile data. Last slide, got lots of things on it that I can talk about in 3 minutes and 15 seconds. If you're in this room and you have an individual electronic communications network service or individual electronic communications service, IECNS or IECS license, please pay attention to the fact that those license terms expire in 2028, 2029. You will need to go through a huge bureaucratic, convoluted process with ICASA, starting at least 6 months before the renewal date in order to get that renewal in. ICASA will probably be sticky about it. So if there's a problem with your licenses, if you haven't paid license fees, if you haven't made the contribution to the Universal Service and Access Fund, if you haven't got the required shareholding by historically disadvantaged groups, if you've done internal transactions to change your shareholding or your membership, but you haven't notified ICASA or applied to them for permission, if those are issues when you apply to ICASA to renew your license in 2028, they will and can refuse. So think about the most important asset you have in your business. Think about the fact that if you have those kinds of problems, they typically take a year or two to sort out. So now is the time to be saying, okay, I realize that we sold that shareholding to someone or we changed our shareholding. We didn't have any interaction with ICASA. Let's go and find out what we need to do and make sure we regularize that position before 2028. Super important, otherwise you're going to find yourself without a pair of licenses which are currently worth about 1.2 million rand. ZADNA's registry and registrar licensing regulations came up about 3 years ago. As I mentioned, There's a lot not to like in these draft regulations, primarily the fact that they want some kind of know your customer process to be built in. Obviously, that disadvantages local registrars as opposed to international registrars. It's a tough enough game at the moment to sell domains. We don't need to make it tougher. We had hoped that those regulations had disappeared, but we hear that they are still in play. Recently, the newly appointed advisor to the newly appointed minister went through them and said there are some procedural issues. They have now been sent back to ZADNA to have that fixed, whereafter it looks like they will be finalized and published. So from an ISPA perspective, we're looking at what we can do to intervene at this stage, try and make the new minister aware of some of the larger issues with those draft regulations and see if we can get them to go away. The alternative is probably going to be litigating once they are finalized. Artificial intelligence, from a legal regulatory point of view, we have nothing. We will continue to have nothing probably for the next 5 years. Okay? There's an artificial intelligence national policy framework being finalized this year, after which they'll start work on an actual artificial intelligence policy for South Africa. And once that's done, which will take 2 to 3 years, we'll actually start to work on legislation. So at the moment, that's really going to be driven by EU Artificial Intelligence Act and its consumer protection approach. And the debate in South Africa is going to be whether we follow that EU approach with risk assessments and risk mitigation for AI, or whether we go more towards the US, where we just put it out into the market and let the market regulate it, maybe take some of the sharper edges off. So there's a huge amount of chit-chat. You can't go to any government meeting without being told about the incredible importance of the AIs and how they're going to revolutionize everything. But we're actually nowhere in terms of a framework for governing it. Can't look at the news without hearing about Starlink. Do we need Starlink in South Africa? Yes? No? Yes?
Yes, if they aggregate it for backhauling in remote areas,
Okay.
Not any other particular reason.
Okay. I'm not a Starlink person. Okay. If I, for example, look at Starlink where it's active in Zimbabwe, the cheapest package there is pitched at about 17.5% of someone's monthly income. That's not an affordable service. So at the moment, these low Earth orbit satellites are good for specific applications. You've got some money, you've got a guest house, you're a farmer, you could club together, absolutely wonderful. But Starlink itself is not something we're going to see in South Africa for a while, unless there is a Donald Trump, Elon Musk kind of development where we're threatened and we give in. Legally, ICASA is looking at reviewing that satellite framework. They brought out a findings document yesterday which says absolutely nothing, so probably another 2 to 3 years until they get that right. The minister, as you will have heard, is saying, well, if Starlink's problem is having to have 30% historically disadvantaged group ownership in the South African entity, because there is a Starlink Services South Africa Pty Limited, which has been registered for the last 5 years, the minister's saying, well, can we not allow them to enter into an equity equivalent agreement? So instead of having 30% shareholding, you commit to an agreement to spend a couple of billion rand on skills development, training, and things of that nature. So a far, if you like, broader form of empowerment than the narrow ICASA mandated ownership. To be quite clear, as things stand, Mr. Musk could give 30% of that company to his mother and get a license from ICASA tomorrow. Mr. Musk could also enter into a local partnership, and he's been talking to a wide range of people around South Africa about doing that, and he could enter into service in the next 2 to 3 months. Starlink has infrastructure in South Africa. It has equipment which is type approved. It has a presence at Jinx and other data centers. So they're ready to hit the ground running, but the politics just doesn't look like it's going to get sorted out. And there's a lot of opposition in the country to giving a special deal to Mr. Musk. IMT spectrum, very quickly, just to note, we'll get another spectrum auction probably end of 2028, 2029, starting to work to that. Also in 2028, 2029, when you're worrying about renewing your IECS and IECNS licenses, the mobile networks will have to go and renew their 900, 1800, and 2100 megahertz licenses. So the original 2G, 3G licenses, which were issued to them in 1996, and that's going to be a lot of fun. Data and cloud, someone asked me about it. There is a policy the government is implementing. It's really got nothing to do with the private sector. It doesn't impose any obligations on you which you don't already comply with. The real issue there is CETA, which is the lead implementation agency, and CETA is a problematic beast which they're trying to sort out. Online harms, that is also going to be a chapter in that audiovisual content services policy paper. From an ISPA perspective, we really don't like this being tucked away somewhere else. We need to take this issue of online harms, child sexual abuse material, non-consensual intimate image sharing, cyberbullying, all that stuff, put it into its own piece of legislation, its own focus, and start to really look at how we mitigate some of the sharper edges of being online. And then, very lastly, and my apologies, I'm over time, the Electronic Communications Amendment Bill is something which will be introduced into Parliament in a year's time. That is to revamp the licensing framework, which some of you will have licenses on. One of the things they want to do is to introduce a new license category for facilities. So the bits and pieces which make up a network, government's idea is to say we want you to also have a license for the components of a network. So we'll certainly be fighting against that, but again, just a little bit of a heads up that that piece of insanity is on your way. I am done and welcome any questions. Thanks. I believe it's customary to get up off your backside and approach.
Quick one, Dom. Very interesting that we're looking at RICA and reform of it, and we're all aware, I think, that it's intrinsically broken, as you pointed out. But under the current situation, I mean, isn't RICA not there? It's a collection of client information to then, so we know who they are to connect to the internet. So what happens in a public free or hotspot environment to a provider? Are they not in breach of those current agreements that are in place?
Hands up anyone who doesn't think they're in breach of RICA.
I know they're in breach.
You're all in breach of RICA.
Yes.
Okay. Because
now,
the words on the page don't make sense.
Yes. But has any action ever been taken that there is probably the biggest non-compliance issue out there in that regard, if you look at the number of hotspot users? And would that not even apply to people in this hotel, sitting here connected to this Wi-Fi?
Yeah, so no enforcement action has ever been taken. ISPA, in fact, went to the department and said, what are you doing about this particular thing? Because it seems iniquitous for our members to have to jump through all these hoops, lose clients, whereas anyone can go to a free Wi-Fi hotspot or a paid-for Wi-Fi hotspot, and they don't go through the RICA process. And we suggested to them that they look at India, where I would verify myself through my MSISDN before I can use a hotspot. Okay, there's an interaction. The RICA database in respect of my mobile phone does the hard work. I then get some kind of code and I can log in. So there's a form of verification. We're not interested, said Department of Justice. Okay. And if I can just give you a story which tells you a little bit about how these things are enforced. So recently, we got approached by the Film and Publications Board. And again, people in this room should know that under Section 27A of the Film and Publications Act, ISPs are required to register with the Film and Publications Board annually, and you are prohibited from carrying on the business of being an ISP if you are not so registered. Okay, cool. They then get approached by the gambling boards to say the gambling boards are raiding internet cafes. And they're doing that because they believe that the internet cafe is running an unlawful interactive gaming, gambling kind of operation. So the gambling board goes to those guys. Those guys at the internet cafe haul out a Section 27A registration from the Film and Publications Board and says, go away, we're licensed. The gambling board goes away. Doesn't do anything further, goes to the Film and Publications Board and says, why are you licensing unlawful interactive gambling? The Film and Publications Board then comes and speaks to me, and it's one of those times where I just feel like weeping quietly and going back to commercial fishing. So that's the state of enforcement of those kinds of things. It doesn't work very well. Hopefully what we get out of this RICA review is something which is simple, practical, pervasive, and is actually useful to law enforcement. Super, we done. Thanks, Boris. No,
One more.
One more.
Sean from Mazanog. Question on the licensing. And so if you have an ISP and there has been significant shareholding changes, etc., you've now not told ICASA about that. Worst case scenario, what happens in 2028? They just refuse to give you a license and you have to stop trading.
Correct.
And if you want to do like relicense, you said something about R1 million. Is that sort of what you're in for in terms of cost relicensing?
Yeah, that's what it would cost you right now to buy a pair of individual licenses on the secondary market, because right now you cannot go to ICASA and apply for those. That will change. In the annual performance plan for the Department of Communications published yesterday, there's a line item for a policy direction to be issued to ICASA to say you must not start issuing these licenses. So by the end of March next year, you may in fact be able to go and apply for those licenses, but ICASA is probably going to charge you 500,000 Rand per license. The easier thing to do is to say, okay, so I've done these transactions. Let me first figure out what the effect of those transactions were. If the effect was not to change control over my company, okay, let's talk about a PTY Limited. In other words, I was 100% and I gave 5% to someone. That's not a change of control. My obligation is to simply notify ICASA. Okay? This is what we've done, and ICASA will say, that's great, we've got it in our records now, accurate. If the transaction actually amounted to a change of control, so you were 100% and you've sold 50%, there's now two people on the face of it, and without reference to shareholding documents, two people that have control over that company. That requires an application to ICASA. Okay? So strictly speaking, you're not allowed to effect that transaction until ICASA has said, go for it. We think that's fine, it's not a problem. And that's the one. The notification one, you'll probably be okay. You know, you go back now, look at it and say, okay, I need to send in this notification, send it in. They'll say this is late, you're naughty, you'll say sorry, and everything will be okay. The application one is far more problematic, because where, for example, a licensee has done that kind of transaction and then gone to ICASA, they've turned around and said, we want you to unwind the transaction. At which stage we all just go, what? What do we do now?
Give
3
the
years
money back
ago
and
we
get
did
your
this
shares.
transaction. That's the reality, and your solution is to tell us to roll it back. That's not going to happen. So those are the difficult situations you really want to avoid. Okay, I've overstayed my welcome. Thank you, everyone.